test right before he leaves when he gets back.
Just,
He
I don't know,
provided me
man.
proof that he scheduled this before he picked up this case.
that makes no difference to me. What's your cause number? Let's not put the cart ahead of the horse.
259-3071.
Yeah, and so what we'll do is we'll give them a portable device. Well, the portable device is not going to work. I don't know what to tell you, man.
When is your army taking a break? I can approach.
No, my concern is that I don't want him to drink, and freezers are notorious for drinking. So I don't know, man.
If it wasn't a crash, we wouldn't be opposed, but if crash into a leasing office, we're gonna be opposed.
Can you say it again?
It's a crash WI where he collided into a leasing office of the complex, we're gonna be opposed.
Oof. The only way is if he puts a scram on. It's the only way.
I can talk to him.
So that way I know that he's not, but
Okay.
what's your other one?
Just a little more, 254-6020. This one is set for Friday,
Oh, she's got,
but she got a new ink monitor yesterday. So apparently it was messed up. It wasn't charging. So she got a new ink monitor yesterday.
they haven't been able to reach her. She's not been checking in. The device has been dead.
I can talk to people, but she went yesterday. She got a new ink monitor.
Yeah, check with them, let's see if she's in compliance. Stacy.
So, she did report yesterday, and when she spoke to the officers, the notes say defendant did not want device inspected and reported no issues. She said that.
She did not want the device inspected?
Yes. And she did have a charger, but she left it at home, so we did not inspect the charger.
Okay, she's got to be here tomorrow. She's got to be here.
She's set for Friday.
Or that's what I meant, Friday. I
Can
meant
do
Friday.
Tomorrow though, because Friday I have a doctor's appointment I need to be at.
Sure.
Okay,
Hey, Stacy. Hi,
I'm here on Mr.
hurry.
Bashan,
Run, Forrest.
Bashan Isaiah Humphrey, who's in custody. Criminal trespass.
Is it under Humphrey?
Yes.
I feel like we've talked about this before, have we
Yes,
not?
he was the one that was at the Star of Hope, but ended up treated in BVR.
What should we do with Mr. Humphrey?
So the oldest case, I think it's 262 days old.
Okay,
I spoke with, the state. But not been able to do a case in the office.
you want to roll it maybe till Tuesday to give them just a little bit of time, and then hopefully we can work out some, he's young, I don't, really.
Yeah, there's a homelessness issue.
Yeah, I don't want to, what's he doing? Where's he gonna go? He
He's
doesn't,
probably gonna go back to the Star of Hope.
but he doesn't have anyone else that'll,
My parents.
friends, family, aunt,
Yeah, it's like
uncle.
a lady friend, but
She,
she doesn't have housing.
okay. We're in the middle of trial now. Maybe you can reach out to Farwell, see if they'll get it done quicker.
Okay.
We have a ton of cases on for Friday, so, okay.
I only have one other thing, it's off docket, but,
Tell me, what's the cause number?
261,
Okay,
2376, Canyon West. He was just here with his mom and his new, treatment coordinator.
how'd it go?
It went well, they talked to you a little bit about it.
I remember.
Trying to amend his bond conditions such that the drug testing that he's getting in San Marcos can count, but the drug testing is supposed to get here. We talked to you about it, but his bond conditions weren't amended that day.
Okay,
Because we're mainly addressing his device issue.
okay, I'm okay with that. Yeah, and just waive the signature if you need it. Yeah, okay, Stacy.
Thank you.
Have a great day. I thought I saw Chisholm. Okay, I guess not.
And just, he did send the drug test yesterday.
Stacy, Rob, you mean with us?
He with us. So.
When is the last time he's taken a test over
I think it
there?
was yesterday.
Are you sure?
Well,
Because they need to get us proof that that they're taking a test. Otherwise, it's
Yeah, he emailed me yesterday, July 7th. Mr. Joseph Kraus was important, and he
but
said,
does he have proof that,
you want him to send the actual.
Yeah,
and-
yeah, yeah, yeah,
He
yeah,
just
yeah.
sent me an email without asking.
that's, I mean, anyone could say, hey, I passed the test. No. Yeah.
I'll ask you.
So let's set it to next week so we make sure it gets done. So we'll give them until, Tuesday to get us the results.
Okay.
Okay?
All right, thank you.
Okay. If not, then a BVR gets filed and then, so please stay on and make sure that it gets done. We don't want to have to drag them over here.
No. All right, thank you.
Okay, thank you, Stacy. Hey, you gave me Rathode. No? Or was he, did you give me Rathode?
Yes.
We emailed you to the police.
Hey, Ramona.
How's, the 23rd? I'm gonna give the,
You don't need to white orange. Give it assistance. You don't have to. It's not. You know.
6 through 7, 9 through 7. Does Spanish ring from earlier?
Okay, is this with Washington?
No. But this one was the one on
But we don't have an interpret. Oh, Luis, all right, come on, real quick.
the bottom of 24. Giordano,
Tell me.
come on. That's a Watson. Watson.
Oh, Watson.
That's a little.
Does he have a Watson?
That's the one that's on.
Oh, that is, okay, fine.
Because it's different.
Yeah, but don't send him down yet.
Yeah.
Okay, all right. Oh, hey, what's on? All
Giordano,
So-
24.
right, good morning, Mrs. Sororzano. You're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On June 2026, in Harris County, Texas, officer was on patrol when he noticed a vehicle change lanes without signaling. Officer conducted a traffic stop, and as the defendant handed his license to officer, he noticed a handgun in the compartment on the side of the center console with a loaded magazine.
So you're saying it was in plain view? Is that what you just said?
Yes, Your Honor, the officer observed it, in a compartment on the side of the center console with the loaded magazine on top of the center.
Okay. Does he have a license to drive?
Right here right now, Your Honor.
Please. Mr. Sorzano, I'm going to find that there is probable cause to go forward with your case. As a condition of your bond, you were ordered not to be in possession of any weapons whatsoever. Otherwise, I will revoke your bond and put you in jail. I don't know what your immigration status is, but if you are not in this country with permission and you go to jail and immigration finds you, they may very well put a detainer on you. You understand? Okay.
This license is eligible.
Okay, we will have bond conditions created for you to sign. Do not leave until you sign them. We will reset your case to give you time to hire a lawyer. Go ahead, we'll have you sign and then we'll get you out of here, sir. Do not leave until you sign the bond conditions. You have Marcus Young. Young? Okay. You are Mr. Young. You're charged with 2 cases, harassment and resisting arrest. On the harassment, you're facing up to 6 months in jail and or a $2,000 fine. On the resisting, you're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement. They're offering you 60 days in jail with credit for the 29 days that you've done on both cases. You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. If you are on probation or parole, pleading guilty to these cases may result in further confinement. Do you understand this? Knowing this, do you still want to plead guilty? All right, how do you plead? I will find you guilty on both cases, send it you to it. We will roll your court costs so you won't owe anything. Good luck to you, Mr. Gunn. Thank you,
The
counsel.
other AFM case is being dismissed.
Oh, okay.
Yeah.
I didn't know that, but all right. Your other case will be dismissed on motion of the state. Okay.
Appears tomorrow, here in June.
Yeah, of course.
It took me hard to.
I understand. I'm always okay with you here. They need to be here. All right, lawyers, Carl.
Yeah, Judge, I don't know if you want to hear anything else. We've had time to read those cases. And we
Okay, but I don't want you to go on a huge diatribe. I think I've already made up my mind, but is she here?
Mr. Rasky was just going to say that the case they gave is obviously was going to.
Where's Miss Shaw? Is she here? No? Yeah, please.
Yeah.
All right. Talk to me. Come on, Al. Bring it.
Matter, I give you the cost number. 2586343.
Okay.
Mr. Johnson.
Okay.
Mr. Johnson has maintained solid attendance with him.
Wait, there's a warrant for his arrest.
Yes, I think what happened was he had just dispersed a bit fast. If the warrant was issued for his arrest, he needed to come in and provide proof that he had been attending.
I'm not, where is he here now? Come up, sir.
He came voluntarily, called our office, invited me all over.
Okay, so I will reinstate the bond now, but I'm not doing any further long resets. So we need to figure out what we're doing like today.
So he's been going.
No. Unless he's done with the class, I'm not doing any more further resets. I'm not doing another 18-week reset for get stuff to get done. He's been MIA for 2 months. I'll reinstate your bond now, but we need to figure out where your case is going.
Yes,
So, stop. No, it doesn't. No. Just take a seat. I'm reinstating your bond, but I'm not doing any further resets. We need to figure out where this case is going. Your case is 9 months old. We set cases for trial at 180 days. Do you understand? Please take a seat. Do not leave. Did you get the cause number? Perfect. Okay, bond reinstated. Ms. Shaw, come on up. Hey. Oh, do you need something else?
You want me to roll Mr. John, JV on back into tomorrow?
Do you have a plan?
We can roll to tomorrow.
Yeah, we can do it today. if you want.
I
Yeah,
think you're in trials.
yeah, write it up and we'll try to get it done.
Yeah. Sorry, on Ricardo there.
Okay.
On docket judge, it's at 172 days, so I'll just tell it to approach. State's made an offer to probation judge, but I just wanted to go through discovery to give my client a
Okay,
chance.
well, I'll give you a week.
That's fine.
Okay,
Thank you.
he's got to be here. Is he here now?
Yes.
Okay, we'll give you a week. You ready? Ready? Come on up. Come on. Or Ms. Brasky, are you doing it? Okay, your motion, you go first.
Judge, we're back on the record.
Guys, we are going back on the record. Do not talk. If you need to talk, please go outside. Thank you.
Okay, so to respond to the case that was presented to us by the state, Rothos v. State. It looks like the issue in that case was actually just regarding if an officer has to actually observe and watch the subject the entire time. But what it also says is that in that case, the appellant burped twice and the officer actually did restart the waiting period out of an abundance of caution. And so, that's what should have happened in this case after Mr. Cruz did burp before the first blow. And then afterwards, after the first blow, he had put his fingers in his mouth and was biting his nails. With the cases that we provided to the state and to the court, we have the Smithy v. State case, where the conviction was reversed because the defendant had something in his mouth, and he also belched during the observation period. The expert testimony indicated that, you know, having a foreign object in the mouth, additionally, belching would result in a test that could not be valid. What we heard from our expert, or what we heard from the state's expert, is that whenever these things happen, it can make a result higher improperly. And then we also provided Garcia the state unpublished case, and we provided this case because the facts we have here with Mr. Cruz are distinguishable from Garcia. In Garcia, the suppression argument was based on an alleged burp that happened, but there was no audio or visual evidence to support this claim. And there was no evidence that supported that there was a burp that actually occurred. What is different with this case with Mr. Cruz is that he had testified that he burped, he had testified that he had his fingers in his mouth. And we could see it on the video as well, which was provided, both the formation of a burp and what happened, and then also with him putting his hands on his face and in his mouth. And so for that, we would be moving to suppress the drug test results and anything that comes after.
Okay. State.
Sorry, and Scott. Judge, this Smithy court case is really about jury charge error. It's also from 1993, where
Your Honor, if I may, 88 Wiley, for the state WILE.
Thanks for coming and helping out.
I appreciate it. I haven't had the pleasure of practicing in front of Your Honor. I've looked over the cases defense counsel's provided. To start with, Judge, they provided the Smithy case and the Rafford case, at least that's how I'm going to pronounce it, but, or we provide Rafford, they provide Smithy. Rafford and Smithy are both non-published opinions, and most are persuasive. They're both from, well, Rafford is from Dallas and Smithy is from Fort Worth. They're from the same area. But of note, Judge, that Smithy was published, or well, wasn't published, but it was written in 1993, whereas Rafford was written in 2024. I'm sure they had in front of them the Smithy case when they were writing that opinion. I won't go so far as to speculate as to why they didn't publish the Rafford opinion. But in terms of which one would appear more relevant to the case, I think Rafford stands out as the forefront, Judge. And in there, at the end of the day, the court decided that it was a use of discretion that they were looking at it under the standard being. There they found the court didn't abuse their discretion regarding letting in the test after observing what appeared to be a burp. And then opposing counsel provided Garcia v. State. Now, this is also unpublished, but it is from our county, Judge. It appears to be almost analogous with our facts. I know opposing counsel put forward to the court that there's clearly a burp seen on camera. I don't know if that is the case, Judge. That's something for Your Honor to decide, not necessarily them. You've seen the video. From what we saw, we had some testimony from the defendant himself getting on the stand talking about how he wasn't even sure if his mouth was open. He had to be pointed to that fact multiple times. So in weighing whether or not there was actually a burp, and I'm sure Your Honor saw he was led through the entirety of that direct.
But out of an abundance of caution, how easy is it to do another 15-minute observation period?
I'm sure it would have been very easy, Judge, and should those have been the facts, I think this would be a much easier decision. I think opposing counsels raised the motion to suppress for a reason. But I think here it just falls short of what would be required to actually suppress this evidence.
Yeah.
It's just that the observation period was done before they got in the room, and of course, it would have been great if they had noticed what appeared to be a burp, or if it was, and they had restarted the time, but as you can see, he was trying to set up the machine, and he didn't even look his way and didn't see it.
So
again,
do they
if
get
it-
penalized because of it? You
Well,
know?
no, Judge, but it's just.
And why is the observation period not on video too?
Well, there was testimony as to why they just don't have enough rooms to put every single defendant to be videoed, and.
With the
it's
advent of
not-
technology now, you can blur faces so that, you know, any other privacy issues, we have no clue who it would be.
Yes, Judge,
But I mean,
that's-
really,
But that's not required, for them to be on video for the result of the test to be admitted into evidence. Counsel can for sure bring it up on cross and allow the jury to give the evidence the weight it deserves or the weight that they think it deserves. But to suppress it completely just based on that, I don't.
okay, you ready? All right, I'm gonna grant your motion. All right. I'm gonna give you back this case law. So where do we go from here now?
Discuss, Judge.
Okay,
Mr. Flood, was this just a verbal motion to suppress?
Well, I think we filed a generic motion to suppress, but it didn't specify this.
Right.
and I can, if
So
you want
it's
to print it out, I
involved-
can just write on it. and
Okay.
and
We'll
just
do
put it
that
on
one
it.
and judge it right.
Yeah,
Judge, can you get a few minutes?
Yeah, take 5 minutes, for sure.
Last name Okor, I mean, last name starts with an O. Oh. Brian O. No, you can come on this stuff. I'm just gonna get you to sign your bond condition. On the keypad whenever you're ready. And I'm just gonna give you a copy. If the lady in the middle say this is all you waiting for. Okay.
After this,
There you go. You're welcome. Have a good day.
Hi, Max, come on up. It's fine. We're
Extraordinary circumstances.
just tell me what's up.
Jury duty about.
Oh, nice. Good. Who you got?
I've got Mr. Miguel Garcia. on docket.
Garcia. Okay, where are we at?
So.
It was restitution, right?
Yes, sir. So this is the case we talked about last week.
Yeah.
We're doing restitution dismiss on $1,500. You wanted us to take a look and see if there's a possibility for the PD's office to do something along the lines of an elephant account. I did check with our holistic division. That's not something I was able to do.
Okay.
But I did talk to Mr. Garcia to see if he could come up with some kind of way for us to monitor and keep track of his savings to get to that 1,500. I think we have a possible compromise. If he's gotten up to 650 right now, has it in a cash app account that he is able to keep track of, send me updates to the balance of that. My hope was that if maybe we could,
So he's got half now.
he's, getting close to having it. 650. I don't know.
Okay.
If the court would be willing for us to reset the case and waive his appearance, I can be here and give the court an update as far as how he's doing and progressing to that.
How long do you want?
If the court wants a quick update, we can do.
No. Where's Mr. Garcia now? Come up, sir. So
At this rate, I think he can probably get it in a month.
would be the hope, because we're now at 180 days. So how long will it take you to come up with the remainder, Mr. Garcia?
What are we on today?
Today is the July 8th.
By the end of the month. Of this month.
Are you sure? Are you really sure? I want to give you enough time, but at the same time, we at some point have to put these cases to bed, and we just can't reset. It just, okay, so pick a day, the first week of August. That is the final date. If it's not done and paid for and dismissed by that date, is there an alternate offer that you have? I'm not doing any more resets after that time.
No, this offer of restitution to discuss has only been on the table since last month.
Sure. Yeah.
What the court's done.
I understand, but I don't want it to drag it to 250 and then 300 because
I just,
our cases are blowing at it.
We have this tax rate for an offer.
Okay, so we will give you to the first week of August. By that time, you must have it paid off and the case dismissed. If not, you must accept either an alternate resolution or I will set your case for trial. This is the last reset. Do you understand? Okay, all right. Good luck, guys.
I'm just gonna do people for a while. Don't worry.
we're on.
That was the fun. Are you on? Make it or those days it will-
We're discussing the big under journey.
Okay.
Regarding the client that with the cruise, the DWI,
Mhm.
as long as he gets, if he comes tomorrow to get the scram, it's okay to go.
Sure. Yeah. Are you guys ready?
Yes, sir.
Then I think, Officer Perez, we got as far as we could with him before
Okay.
the motion. So, you can be excused,
Okay,
the two, technicians, I guess they can be excused.
yeah, okay,
And, be ready to close.
okay. So what we'll do is we'll bring him in, rest. Okay, and at that point, I'll ask to see if they have any witnesses and then we'll go from there. And then if they arrest, do you have any witnesses?
We're going to rest.
You're gonna rest? Okay, so at that point, we'll just get the charge ready and then we'll do closings. Do the charge and closings. Yeah?
Before we get into it, can we have, a little bit of time just to.
But they've been sitting there since 9:45. I mean, it's already now 11, nearly 11:30, like 2 minutes, right? But yeah, all right. So I'm gonna bring him in at 11:30, okay? Okay. So guys, please, at 11:30, if you don't mind bringing the jury in, okay? It's okay, don't worry about it. So really, they're gonna be in and they're gonna be out within the next 10 minutes. And then what I'd like to do is have them eat lunch while they deliberate. So that way, just hold off on giving it to them until ready to deliberate after closing. Hey.
Is that Matt Post?
Yeah.
Mr. Tacano, Your Honor, Abdul.
What's the last name? Is Abdul?
ANK
10,
and
okay,
then ANO.
10, cool. I see it, okay?
So like $1,000 in EPS fees, he paid 600. He's trying to pay the last 400. The state has made a PCI offer. The case is old, it's from January 1st.
Where, is he here now?
He is here. I think he just went in the hall, but I went around the back to go talk.
Okay, do you mind bringing him up?
I asked, I'll let him grab him right back.
Thanks. Hey, talk to me. Shoot.
On the docket, we're doing jail reentry. I just filed the release
Yeah,
instructions.
I'll sign it for you.
Okay, thank you.
Yeah.
Are you doing the political?
Yeah, we're doing jail reentry.
Around.
Oh.
Your case is 190 days old, sir. We set cases for trial at 180 days. You have another $400 to raise, but understand it always takes DPS at least 2 weeks from the day that you make a final payment for anything to reflect in the system, at least. We cannot hold this case open forever. I will give you one final reset, but at that last setting, that's it. If it's not all done, then another resolution we'll have to find. You understand? At the next setting, it's your plea bargain deadline. You must either have everything done, or you must accept a plea bargain agreement, or we'll set your case for trial. Our dockets are ballooning out of control just because over. But that's what I'm saying. I'm going to give you one final setting, 30 days, but this is the last reset. Do you understand? So don't wait till 2 days before the next setting to just pay everything, because that's just not going to work. Do you understand? All right, so 30 days and then he must appear, and then that next setting is clear trial.
Yes, sir.
All right. All right, sir, we'll have you take a seat and then we'll have you sign a reset momentarily. Do not leave.
Thank you. Your Honor, regarding Mr. Bradford, did you, Mr. Johnson, your docket matter, did you want him to come back in 2 weeks? The gentleman who in the.
I remember, what, you have an agreement worked out? Mr. Johnson, do you have an offer on the case?
He's already taken, he's supposed to provide proof that he had enlisted, enrolled in fit. That was what happened. And he admits to it, but then he came, well, he went on vacation, he came to court, the MAC paid for him to come to court to prove that he was coming in. And then a warrant was issued for his arrest because he didn't come back. But he has been going continuously since then.
Show me proof that he's been going. I want to see it. I want to see how many classes that he's absolutely done. The case is 9 months old, man. I can't just keep resetting it, and especially if he takes off and for 2 months.
So. You should work on it?
Yeah.
Well, I'll email you the more formal one, but that's from the coordinator. Yeah. He's been going. He had 2 absences in the beginning, his car broke down, he's been going.
When did you offer the BIP and dismiss?
We offered it on April 22nd, 2026.
Completed enrollment is May 1st, 2026.
Okay. If he misses any more classes, he will be set for trial, and I'm not doing any more resets after that. If he ever misses another day, if he ever misses another class, we will set it in 3-week increments to provide proof that he's done at least 3 classes every 3 weeks. We'll have to micromanage it, but if he misses another class, Alan, he gets immediately set for trial. Okay, all right. So go ahead, set it 3 weeks. No more waived appearances either, because it's just that 9 months is too old.
Yes, sir.
Okay, thanks. If you provide proof prior to the court setting that he's got the 3 classes done, I'll waive it.
Thank you.
Okay,
Yes, sir.
okay.
Regarding Mr. Bradford, Your Honor, we're just waiting for, I think, Chief.
Sure. Yeah.
Thank you.
Yeah.
Mayor Pritchard?
Please. Alan.
Oh, thank you. That's very important.
I had a coach last week on a Carlton Jackson motion to restore property. You would want proof of, I guess that he purchased it. He did go back to the store that he bought it from. They weren't able to print the actual receipt, but they wrote the receipt stating the date they wrote the receipt, the serial number, that he was the one who purchased it on the date that he purchased it.
Is it on their, it's not like on a bar napkin, right? It's on their actual, yeah, of course.
And I've attached it to the motion to restore property that the clerk said she would put in your queue.
Have you seen this?
I have not had a chance to look at the.
Okay. If you want to send them a copy too, so that they can have it for their records. And then if you don't have any objection to it,
It's a piece it's a rifle.
I don't know if you want to.
Could you just send that to us so we have it in our files?
Absolutely.
What's the call number for your case, please?
It is 262
Okay.
0056.
Did you guys?
Yes.
Man, you guys are good. Good job, really. Okay. Hey, you guys ready? I'll grant your motion, subject to their objection, of course.
Thank you.
Are you guys ready?
Yes, sir.
Okay. We're getting the charge ready.
I'm working on a draft right now.
We are too,
Oh,
so that way you don't have to.
And you have this class one. That's the problem. I can tell you informally.
I know, we'll do it both. Just tell me what your request is and then we'll get on the record.
Requesting that the point language of how to convict be removed since there was no evidence.
Okay.
presented of that.
Yeah. I'll grant it for you.
Yes, we had no objection.
Okay, got it.
Thank you.
Just let them know to put it in queue. Okay, anything else?
Judge, you want to sign real quick so she can get a copy?
No.
Yeah.
Okay.
that's what I'm saying.
Ramona, did you hear that?
Judge, he just wants the .08 removed from.
Not yet, not yet. Let me,
Judge,
did they just get here?
They got here a while ago.
Oh, yeah. Okay, Kyle.
Just give us 30 days.
I've been here since 8:30, you know.
But you have to.
Oh, okay. I guess I could just give you a call. Yeah,
Marcus. Marcus to make.
Good, bro. You don't worry. Sir.
Oh.
almost.
Michelle, come up, please. Guys, can you come up real quick? Ms. Brasky? Kylan, give me a second first. Hold on. Sorry. I'll sign, just tell him to put in, I'll sign. Hey, look, I've got the jury charge. Take a look at it because once we bring him back, I'd like to get everything done. That way we can send them back to eat lunch and they can just deliberate, you know? Take a look, see, do you have an objection? No objection. We'll get it on the record. Then after that, we'll close. You close, rest, they'll rest. We'll do the charge or and then closing to end. Hey,
Friedman's been fun to do this work.
really? What? What?
This is on MARDIS.
Great, so you're signing on? Okay.
Need one reset to get around everything. I have the notes in Plato. I'm going through it. There's an operation issue.
So you're what? Okay, yeah, we'll give you a setting. Okay, he's got to be here at the next one. If you guys want to do PTI, if he wants to do PTI, please be ready.
I know.
Yeah.
I know what to expect.
Got it.
Thanks.
Have fun. Mr. Washington.
Not on the board, I have two other names.
Okay, talk to me.
So the first case is Andrew Pennington.
Okay,
And
I mean, it's 96. I don't care.
okay, and then the second, Robert Haggard, HAGG.
I don't care until it gets old. Like, I don't care until it gets old. Unless you're missing evidence, then let me know.
Yes.
But otherwise, I don't care. You're
Yes.
good.
Thank you.
Have fun.
Yes.
Oh. Who? Yeah, yeah, of course. Is it a jail plea? Oh, I see, yeah. Around.
I'm gonna get the right person. Thank you. Judge, can I question?
Yes, I'm ready. Are we doing time, sir? All right,
No objection, state judge.
great. Is there restitution that's owed in this on Ryder? Do you mind looking, please?
I can't, yes, sir. What was the name?
Ryder, REI.
They verified restitution was paid. They verified.
Looks like there was $1,000 that's subject to the state.
And it was,
And there was a victim service receipt that was up.
yes?
Yes,
Got it. Okay. Ms. Ryder, you're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that this charge will go on your record. It will be there for the rest of your life. From now on, you will be facing a minimum of 30 days in jail for any new cases that you pick up here. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You gave up the right to appeal. If you are on probation or parole, pleading guilty to this case may result in further confinement. Do you understand this? Is this what you want to do? How do you plead to the offense of failure to stop and give information? I will find you guilty, follow the agreement, send it you to it. Good luck to you, man. Please see the clerk. Thank you.
Ask one question, just on the record. Ms. Ryder, I'm not your actual attorney. Your attorney is involved when you agree.
Oh, that's
I can
right.
Sit in for you.
So hold on, I will make a docket notation for you so that he's not here and that you guys, she approves of it. Okay,
Thank you.
great. Thank you so much. And thank you for reminding me. Totally forgot.
Mr. Payne, can you just keep the notification from the election to the first floor? For those of the insurance supervisors
Okay,
to the
Hey,
second-
guys, do you have any objection to the,
Not from the defense.
Okay, so guys, we're going on the record now. Please do not talk. If you need to talk, go outside. All right, we are back on the record in cause number 256-5785. State has rested. We have not done this in front of the jury. We will do it momentarily here, but out and in an effort to be efficient, we have given a copy of the jury charge to state and defense. State,
Sir, we're on the record, you have to be quiet.
sit down. State, do you have any objection to the charge?
No objections, Your Honor.
Defense, do you have any objection to the charge?
No objection.
Okay, that being said, do you mind bringing the jury in? So the roadmap is you rest. I'll ask you if you have any witnesses, you rest at that point, do the charge and then closings. 10 minutes, 15 minutes for closing. Okay.
All right, for the jury.
All right, everybody, please be seated. Members of, or, I'm sorry. State, do you have any more witnesses? Okay. State, having rested, defense, do you have any witnesses?
Defense rests.
Okay. Defense having rested now. Members of the jury, the defendant, Jaime Cruz Jr., stands charged by information with the offense of driving while intoxicated in Harris County, Texas, on or about May 24th, 2025. To this charge, the defendant has pleaded not guilty. Both sides will soon present final arguments. Before they do, I now give you the instructions you must follow in deciding whether the defendant has been proven guilty or not. You will first receive a written copy of these instructions to take and use during your deliberations. First, I will give you some general principles of law that you must follow when deciding this case. Then I will instruct you on the rules that control your deliberations. Finally, I will tell you about the specific law that applies to this case. The information. The information is not evidence of guilt. It is the name of the document required to bring the case before you. The information cannot be considered in any way by the jury. Do not consider the fact that defendant has been arrested, confined, or otherwise charged. You may not draw any inference of guilt from any of these circumstances. Presumption of innocence. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proven beyond a reasonable doubt. The law does not require a defendant to prove his or her innocence or to produce any evidence at all, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt. After careful and impartial consideration of all the evidence in the case, the presumption of innocence alone is sufficient to acquit the defendant. The burden of proof throughout the trial is always on the state. The defendant does not have the burden to prove anything. The state must prove every element of the offense beyond a reasonable doubt to establish guilt for the offense. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. It is not required that the state proves the defendant's guilt beyond all possible doubt. It is required that the state's proof excludes any and all reasonable doubt concerning the defendant's guilt. If the state does not prove every element of the offense beyond a reasonable doubt, then you must find the defendant not guilty. If after you have considered all the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. As jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and believability of the witnesses, you must apply the law provided in these instructions. The evidence consists of testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, mention anything that is not in evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not in evidence in the trial. Statements made by the lawyers are not evidence. Questions asked by the attorneys are not evidence. Evidence consists of testimony of the witnesses and materials admitted into evidence. Nothing I have said or done in this case should be considered by you as an opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meaning provided in these instructions. While you should consider only evidence, you are permitted to draw reasonable inferences from the testimony and exhibits that are justified in light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts that has been established by the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits admitted into evidence will be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. You must follow these rules to request that testimony be read back to you. The court will allow testimony to be read back to the jury only in a writing signed by the foreperson, and 1, states that it is requesting testimony be read back. 2, states that it has a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identifies the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in disagreement. The law requires that you render a verdict of either guilty or not guilty. A verdict of not guilty simply means that the state's evidence does not prove the defendant's guilt beyond a reasonable doubt. You may return a verdict only if all 6 of you agree on the verdict. When you reach a verdict, the foreperson should notify the court. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf. The defendant may also choose not to testify. The defendant's decision not to testify cannot be held against him and is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he testified or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. You must follow these rules while you're deliberating and until you reach a verdict. After closing arguments by the attorneys, you will go into the jury room. Your first task is to pick a foreperson. The foreperson will preside over your deliberations and conduct them in an orderly way. Each juror has 1 vote, including the foreperson. The foreperson must supervise the voting, vote with other members on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. 1, You must not discuss this case with any court officer or the attorneys or anyone not on the jury. You must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, you must all stop your discussions about the case until all of you are present again. You must communicate with me only in writing, signed by the foreperson and given to the judge through the officer that is assigned to you. You must not conduct any independent investigations, research, or experiments. You must tell me if anyone attempts to contact you about the case before you reach a verdict. Your sole duty at this point is to determine whether the defendant has been proven guilty. You must restrict your deliberations to this matter. After you have arrived at your verdict, you are to use one of the forms attached to these instructions. You should have the foreperson sign his or her name to the particular form that conforms to your verdict. You are instructed that a person commits the offense of driving while intoxicated if the person is intoxicated while operating a motor vehicle in a public place. In this regard, public place means any place to which the public or a substantial group of public has access and includes, but is not limited to, streets, highways, and the common areas of schools, hospitals, apartment houses, office buildings, transport facilities, and shops. Motor vehicle means a device in, on, or by which a person or property is or may be transported or drawn on a highway, except a device used exclusively on stationary rails or tracks. Intoxicated means not having the normal use of one's mental or physical faculties by reason of the introduction of alcohol into the body. Now, therefore, if you believe from the evidence and beyond a reasonable doubt that the defendant, Jaime Cruz Jr., on or about May 24, 2025 in Harris County, Texas, did then and there unlawfully operate a motor vehicle in a public place while intoxicated, then you will find the defendant guilty of driving while intoxicated. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty. I have signed my name to these jury instructions. We will now allow, and each side will get 10 minutes to present final arguments. After that, you guys will be excused to the jury room to start your deliberations. Okay?
I have left, offline in,
How much time do you want?
I'll use, 1 minute or 2 minutes at the beginning
And then,
8 minutes for the.
got it. Okay. All right. You may start.
Good afternoon. I'm sorry about all the wait. I know it's frustrating, but let's get into the facts of this case. We just want to look at the big picture first, right? What happened that night? We talked about choices and consequences in opening. And the facts are that the defendant that night decided, after one night of drinking, admittedly a 6-pack of beer, get behind the
I
wheel.
don't object that statement was not presented, and evidence wasn't proved.
Sustained.
After having a 6-pack, get behind the wheel and drive on a highway, not 10 minutes, not 10 over the limit, not 15 over the limit, 20 miles per hour over the limit. He was stopped, and you saw with your own eyes, his demeanor, the way he conducted those tests. I want you to just look at it with mom eyes, dad eyes. Your child walking home. What clues are you looking for to see if they were drinking or not? Are they stumbling? Can they walk a straight line? Just think about what you saw on those videos. Could he count straight forward? Those are the facts that we ask you to take a close look at. You'll get to take the videos back with you and rewatch it again if you want to, and I would strongly encourage you to do that because this is an important crime. This is not you know, it is in misdemeanor court, but it could have been easily been felony. So, it could have turned out,
Your Honor, I'm gonna object. Inflammatory remarks about how it could have turned out differently or worse. I think it's inflammatory and improper.
All right, overruled.
so the consequences of somebody's action in this case, not only can come back to them, they can come back to all of us as a community who share the roads. So I want you to look closely at what happened on that video. Not get bogged down on the details that the defense is going to try to throw these darts at you. Oh, well, this was because of this was because of that. And make a decision for yourself. And after the defense gets up here and talk, I'll come back and talk to you more and we'll wrap it up.
Thank you, Michelle.
May I judge?
Please.
So, you know, this case isn't about just using your common sense. I mean, certainly, we don't want you to leave your common sense at the door, but the state said this is a misdemeanor case. The burden of proof is not any lower. It's not any easier for them to saddle a person with a criminal conviction for the rest of their life just because it's a misdemeanor court. It's the same very high burden of proof. I mean, first of all, you know, you're the judges of the facts and the credibility of the witnesses, and from what you heard, I have a feeling there's some questions on what kind of a grasp did these people have on their testing abilities, on their ability to make accurate decisions when there were a lot of questions about field sobriety tests, not knowing what the clues they're looking for, not knowing how to score them properly. One of them not even knowing how to do the tests at all. But I talked a little bit about, you know, it's like this mountain that you have to get to the top for beyond a reasonable doubt, or else you can't say guilty, you can't convict somebody. And I indicated you would hear some evidence. I think you did. Remember, it is not illegal to drink alcohol and then drive. You can't drive while you're intoxicated. And just because they put those words on a piece of paper, that doesn't mean that Mr. Cruz is guilty of DWI. That's what you're judging. You're scrutinizing everything they can present or what they couldn't present. So I anticipate that some of these, you know, may not like some of the issues. Some of you may not like the fact that the person drank and then drove. But where does that get you? You can still find that there was some evidence, but was it so compelling, so believable, so reliable that you're like, I have no reasonable doubt? You sign that verdict form, you're like, yeah, absolutely. Some cases, they've got stronger cards. Some cases you would say there's no reasonable doubt. I don't think that's this case. We weren't trying to waste your time by having a trial. You know, there's a lot of issues we blame on technology that caused to be a little cumbersome to get through. But this is the question: how much evidence did they present, and how convincing, and did they get to the top of where they have to for a conviction? So if it's, I mean, this is like what you heard. You know, they just have to have probable cause to make an arrest. That doesn't mean a person is guilty if an officer makes an arrest. So this is kind of the way I feel this way. You know, you start out with suspicion, and you heard evidence of 2 sobriety tests. You heard evidence that there are 3 that are standardized and validated, that you only heard evidence about the walk and turn and one leg stand.
Objection, Judge, maybe approach.
Sure.
Judge, each
I know, if you're gonna open the door,
He said that was. They asked.
I understand, but I mean, if you're gonna open the door, you're gonna open the door.
I get that.
But it's intended to confuse them and hey, don't open the door. Okay, that's it. No more warnings. All right,
Sorry, Judge, just to be clear. I kind of the fact that there was a particular reason why the third one wasn't going or was there.
say it again.
Since he's not talking about their last three, can I talk about?
If you're gonna get it up, it's not fair to them, right? But my test to confuse, you know that's confusing. It adds to confusion and it's not fair because then they don't get to respond, you know what I mean? So just please, I'm gonna instruct you to disregard that. Move on, don't mention any more, please. Which election? Okay, but they mention that though. I mean,
That's fine.
don't talk about it. So let's do this. Mention that, and that's what you're referencing now, so they know that that's what you're referencing. All right, okay,
May I continue?
please.
So you heard the Sergeant Ryan, now Corporal back then, but you heard him talk about a scoring sheet for the field sobriety test. And there were alternate tests that are available to him to use in certain situations, because certain individuals have different characteristics. And you specifically, there were 4 tests, the finger count, Romberg, alphabet test, and the nose touch test that were available to them to use and provide you more evidence. I mean, that's their job. If they're trying to convict somebody, bring you all the evidence that they possibly can. It was even, as he admitted, on that scoring sheet, and he did not even, you don't have that evidence. You don't have any of those tests to consider. So it's like you have what you heard, and then it doesn't go all the way up to beyond a reasonable doubt. It's like it comes back down. And you'll notice that, well, it's like they're asking you to then assume and fill in the gaps and do their job for them. That's not your job. They've got the job to prove this. So, everything is based on proof and evidence. Proof. Not let's assume things that weren't presented. And the judge just got finished telling you that you can only consider evidence and testimony that was presented in trial. And I'm asking you to make sure everybody adheres to that rule. And based on the officer's testimony, we don't want to assume things that we don't know. We don't want you to speculate. That's not how you come to a decision. It's based on the real facts, the proof that you heard, and you get to decide if it was enough. But speculating about things that you don't know or weren't presented is not allowed. It's not allowed. And you heard, so there was, in Bordier, I guess you heard about 3 ways that they could prove intoxication. Not having normal mental faculties, not having normal physical faculties, or a .08 or higher at the time of driving, the BAC. Well, when you go back to deliberate and you look at the part that says the law on driving while intoxicated, you'll notice that there is no language in here that talked about a VAC at all. So this is not even something that you can consider or talk about at all. There was no evidence of a VAC level produced in proof at all. And when it came out, that was the end of, when it just came out, that was time before, that was the end of the evidence that they could present. So, y'all kind of, I hope y'all get along back there in deliberations. Sometimes they can get a little heated, but you're each other's keepers and you have a duty to stop one another. If somebody says, well, we think this might have happened, or it might have, it was probably this, you've got to put your hand up and say, you know what? We're not allowed to talk about that. You heard Judge Fleischer say that. That would be true misconduct. I don't think any of y'all are going to do that, but you got to say, stop. That wasn't presented in evidence. We're not even supposed to be talking about that. You can only consider what was actually presented. And, you know, regarding these two, your opinion is the only one that matters, obviously. But I was telling you that by looking at this video, this isn't that case where you see a person on video and you can tell beyond a reasonable doubt, man, that person is wasted. They're intoxicated. That's just not this video.
2 minutes,
Not this case.
2 minutes.
Thank you, Judge. But obviously that's for you to decide, and you get to take into consideration the things you heard. First of all, who's it? Yeah, Ryan said that certain things you look for, like when a person gets out of a vehicle, if they have trouble getting out, that can be a sign of intoxication, or if they have to hold on to the car for balance, that can be a sign. He said he didn't have any trouble exiting the vehicle. He didn't hold on to the car, but he writes down Ignacio had bad balance and had to hold on to the car for support. And I don't know where that came from. Who's Ignacio? I think it's kind of important to get details right in an office report that they're trying to present as evidence, and throwing in somebody else's name and things that weren't observed that's not even a part of this case. I think that's concerning. Ryan said that the only reason that he pulled over Mr. Cruz was for speeding. He acknowledged freely, according to all those minutes of clues about driving, speeding is not a sign of intoxication. That's what he admitted. And he didn't say that there was any other driving facts that he noticed that indicated intoxication. Perez said that the state asked 2 or 3 times. Well, it's not unusual for the primary officer to not do the test, but do the offense report. And they asked him a couple different times. And he said, yes, that would be like not normal. And he said, yes, that would be very unusual. And that's exactly what happened here. Ryan called out for backup, and he said the purpose of Perez coming out there was he wanted Perez to take over the whole DWI investigation, but he didn't do any of those tests. And then you heard the question, like, what did you see? He didn't know how to do them. But that's concerning because he was working this special grant-funded STEP program of visa. They have to qualify, and their job is to go out. There's different pay. They are out there making DWI arrests using grant money from taxpayers, and he has no idea what he's doing. He's just out there and did what Ryan told him, just arrest him. And he said, really? That's reasonable doubt right there. So what this comes down to, you can only consider mental and physical faculties based on those awkward balancing tests, whether you thought the officers even got it right, if they really knew what they were doing.
All right, man.
Okay, so
Final thoughts.
be strong out there. Only consider the proof that was presented. You can't talk about the VAC. And so my last thing, I mean, there was no evidence of a VAC, but we want y'all to come to a unanimous decision. But if you feel that the case wasn't proved beyond reasonable doubt, not proved, means The not guilty means not proved. And if you feel that way, don't let anybody change your mind. Stand your ground and be strong, no matter what time it is. It gets heated back there. If that's how you feel, that they didn't prove it beyond a reasonable doubt, stand your ground. Thank you very much.
All right, thank you. Yep.
If you, opposing counsel, after arguing, being told not to open the door, they were suppressed. I counted at least 3 or 4 times, and he got in, felt one dozen on all. He got in there and he mentioned 3 or 4 times that there was VAC. You guys didn't hear about the final remark actually even touching on the fact that there was VAC. There was no evidence presented. Opposing counsel knows why that evidence wasn't presented, and he's now misleading the jury as to why it wasn't presented. I understand if your quote would say that you didn't see any of the evidence presented, but to continue to emphasize it and to use it as a argument, it leaves a misleading impression, at least the state's position, Judge, and that's why we might be approached to know, can we rebut that?
What's your position?
I'm allowed to talk about what evidence was presented and what wasn't.
So they're allowed to rebut it too, then. They're allowed to rebut it as well, man. They can rebut it as well.
Respectfully, there was evidence presented. It was prosecuted.
But you told me you weren't gonna mention it anymore.
Well, I believe you know, I said it was not. She had not comment on what evidence they had. It's important to bring that out of the place, and they said they can.
What do you want to say?
But they did talk. Yes. And that he was given rent, so they heard that.
So what do you want to say? What did you have in mind?
Just presentation. That's the reason.
I would just say that we're asking to anyway touch on Fifth Amendment. I would say that he said that there was no evidence presented over at this. I think we should be allowed to comment on the fact that, ladies and gentlemen, there are many reasons why breath this could not, would not be presented to the jury. And that's not something they say. There are many reasons why it's not. They could not. And that's it. I don't want to go into politics. Obviously, we're not asking to reopen the state's case or anything.
Sure.
No.
But I mean, you.
There's an acceptable comment on the fact that some sort of. That's what.
But you got into it. How's that fair?
Didn't hear the evidence of it, and why you
But like I've repeatedly asked you throughout the entire trial, not to get into the stuff that's been suppressed, and you've repeatedly pushed the boundaries of it. Like repeatedly, even if I asked you repeatedly time to time.
I didn't say it was suppressed. I said.
You're getting into that there's a breath test.
I'm sorry, Judge. What evidence was not presented, and it's the judge referencing the charge as well. I don't think I did anything. Certainly is not about. Didn't tell the jury. It's something that's suppressing.
I mean,
It's not. How do I not comment on evidence that wasn't presented? Judge, if I may, there's well established in case law that not that it's more of an analogy about the draw judge that I can't take a swing at the opposing counsel with the big shoulder of his client. If I were to go just stand directly behind him and then look at the jury and continually go, and y'all didn't see a breath test, and then look at him and they go, and y'all didn't see a breath test, and then look at him again. That would be extremely improper. Now, have I commented outside of what was presented? No, but we all agree that that would be an improper argument to make in the same way of positioning consistently that you didn't see the evidence of breath test and then trying to hide. A motion suppresses a shield, Judge. It's not a sword. Judge, I don't know. I was careful with my comments. The evidence.
The exact comment you said, you were talking about the breath test and that they didn't have a breath test.
There's no evidence, there's no proof. You can't consider that, you can't talk about it.
But now that confuses them.
I'm sorry, that's what happens when there's issues like surprise.
They get the opportunity to clear up any kind of confusion though.
They can't explain why it's suppressed that. No. The most we would say that there are many reasons why a breath test may not be brought forward, and that's it. It's the same ability. We're leaving them in the same boat almost of he's presented outside it wasn't presented. We just like to present. There are many reasons why, and we're not going to get into why they wasn't presented. I'm not going to ask to reopen the case. I'm just asking that we say at least report to them that there are many reasons why. And if opposing counsel, that's
You alluded to it as well. You know, you alluded to it, and you alluded to it many times.
My comments on what evidence was present in the trial to allow them to make certain decision.
You even asked for the breath test to be pulled out of the,
Right.
and I agreed. We pulled it out, right? And but you're still mentioning it on top of that.
That it's not, they didn't hear any evidence of what the state talked about in the door diary. We heard it said, they mentioned it. They're not say that, now if they say that they're going to say the way it does. You talk about misleading the jury, they're going to think it was a breath test. He would not be arrested if he was went away. That's a problem.
Okay. So for purposes of the record, I'm gonna find that you can get into just that and that question or that statement alone. Do not get into anything else. Don't get overzealous. Nothing else. Just explain in respect to with what he's saying multiple times. Beat it to death. Don't over and over. No, one time, and that's it. All right. Okay.
Yes, come back. 3 times.
Say it again.
I think I've tried to get my case over on the BAC didn't come out. Language was removed. I commented that there's language no.
You clearly multiple times alluded to the breath test. Clearly, several times. And I asked you not to do it. And
No, nobody said that. You said you nobody requested it.
we're not talking about the issue. You're about the breath test.
But there was no evidence of it.
All right, let's go back. Just finish.
So I'm just not saying many reasons. Yeah,
She's just gonna say that.
Jury's coming, he said, technically, or something like that. They don't. It doesn't sit well. I don't want them to be somebody.
I asked you not to bring it up. And I've asked you multiple times for the trial when something is do not bring it up.
Respectfully, that was never discussed. We mentioned the DNC and the lack of those.
When I've suppressed something for you in this trial, I have multiple times asked you not to bring it up. And you have brought it up multiple times after that. And it happened with the breath test just now, multiple times again. Great. I'm gonna let them get into it as well, just for that period.
You have to excuse all the other notes I have here, but it is that statement I read, and you have to excuse my handwriting. And my opposing counsels. But I'd like, I was attempting to keep it from even mentioning Venable, and just saying there are many reasons. I mean, something is, one reason. There's consequences, you don't have that. It's okay to me, they didn't hear any of that. Because they didn't
Did you show him? Show him real quick. Okay, all right, let's go. Hey, make it quick. Don't be, that's, all right. You have 8 minutes, please, Ms. Shaw.
So, I'm gonna go over intoxication. We talked about the ways of us proving to you, intoxication, and that was loss of mental faculties, or, and let's remember, it's an or. 3 of you could believe, I can see loss of mental faculties. The other 3 can believe, I didn't see that, but I could see loss of physical faculties, normal physical faculties. You're still unanimous. You don't have to all agree on one or the other. It can be either or. Either one is fine. So let's talk about loss of normal mental faculties. We talked about it during jury selection, and somebody asked the question, what's normal? And I would want to submit to you. We watched the footage of the camera. He could not count the steps. The officer told him multiple times, 9 steps forward, 9 steps back. How many did he count? 10 and 10. That has nothing to do with somebody's weight. That has to do with your loss of mental faculties. It's not normal for you to hear 9 3 times and still do 10. Counting again with the one leg stand when he was counting. Please pay attention to that when you get the videos back. You get to watch them again. I ask you to do that. Split hair over it, look at it. He's counting, towards the end, he's not even counting the 1000s anymore. He's counting the 1000, 15 twice, 13 twice. Those are loss of normal use of your mental faculties. That's it. That has nothing to do with your weight. Now, about loss of physical faculties, stability that we talked about. Yes, maybe if somebody's overweight, it would be harder for them to balance. But it wouldn't be harder for them to put their heel to toe together. It would not. Heel to toe. It would not be harder for them to take the turning steps. That has nothing to do with your weight. That's it. He missed all of that. He didn't do any of that. The clues that we were talking about. He missed, he had 5 out of 8. The clues on the one leg stand, he had 2 out of 4. Council was talking about Officer Perez and not knowing how to do the field sobriety test. Well, that's why he didn't do them. That's why he told the other officer, he told Officer Ryan, I'm not gonna do the field sobriety test. That's why he was observing. The only thing he did was take custody of the defendant and turn him in. He was giving you all his opinion as of today, watching the video, but he did not perform the test. Why? For the same reason council is pointing out, because he didn't want to do it wrong. They want to make a big deal about that, really? That he made, that's not a, oh, really? They want to make you think like, oh, really, you're gonna get him? Oh, he doesn't seem drunk. He never said that. It's like, oh, really? Okay. He's just there learning at the same time. That's why there are multiple officers on that scene. It's not uncommon for officers that are in training to be on the field still working. The fact of the matter is, he admitted to drinking a 6-pack. A 6-pack is a 6-pack. The defense wants you to believe that, oh, he didn't say alcohol. what is this, a 6-pack of Coke, 6-pack of water? Oh, what were you doing at your friend's house? We were drinking water. Who refers to drinking anything else other than alcohol as drinking? We were drinking. Those are all evidence. I want to submit to you this, again, the jury charge. It says, while you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits that are justified in the light of common experience. What does that mean? To take your own common experience, or your own common sense, what Judge was saying during jury selection. You take a look at it. If it walks like a duck, it talks like a duck, it's a duck. It's not about, what is one thing here, that it's a whole picture. Somebody drinks a 6-pack, drives 20 miles over the limit at 4 o'clock in the morning. Gets out of the car, can't even walk a straight line, can't even count correctly, can't make a turn, falling over. If you can't walk a straight line, should you be behind a wheel going 20 miles per hour over? That's a question I want you to ask yourself. Make sure that I covered everything that I had here. Just, I would again want to ask you, look at the things that he says, look at the way he's talking, he's mumbling. All of these are signs, all of these are, you can infer again from your own experiences. Does this person look well enough to be getting behind a wheel? Or to me, do they look intoxicated? Do they have their normal use of mental faculties with them? Do they have their use of normal physical faculties with them? The physical one was again, like I said, 3 of you can say, I think I see physical, 3 of you can say I see mental. Again, let's remember counting. A 2-year-old can do it, but can't do it when there's alcohol in your system because you can't focus. So I really appreciate you being here. I really appreciate your time. We're sorry about the wait, the back and forth. Again, council brought up the point that you don't see any DAC. There are many reasons why you wouldn't. So, thank you.
All right, thank you so much. All right, ladies and gentlemen of the jury, it's now your turn. We have lunch for you. We will now ask you to rise and retire to the room to begin your deliberations. You have an officer here at your disposal. Just whenever you're ready, let us know. All right. Oh, just go ahead and lean back and then I'll talk to you. Okay, please. Yeah, I know. That's what I'm for. There. Hey, you be seated.
No, it's not.
We're still on record.
Sure. Great. Oh, no. Where does the Javon? Oh, I don't know. That's fun. Yeah. And then they should get lunch too. And then, hey, remind them 2 dings for verdict. Okay, all right. I'm sorry, Justin.
Are we off the record now?
Well, off the record.
Just,
Hi.
Governor Michael still in
Sure.
custody. I just want to go over to tomorrow.
I can't do that. Because the thing is that our jail docket is bigger than our normal docket. And we have so many people on the jail docket. We've now gotten to, we're putting people in 8 and they don't have space for their people. Because we have so many people that we literally roll day for day for day. So I'm happy to, if there's something meaningful that's going to
They
happen.
haven't done a writ in 6 months on that case, and that's why I'm having to approach, because the age of those cases. She didn't help, just 3 class.
I understand, but she did recently pick up the new case, right?
That case is $200 bond on a criminal trespass, which is outside, like, the grass of a Walgreens.
I've done all this. I've done it with you over and
I'm
over,
not
right?
asking her to be released yet. I'm just, you want to
Yeah,
plan, I got communication with her dad and her brother.
So let's put it on for Monday or Tuesday. I don't want to just keep rolling it for day, just because I'm telling you, our jail dock is bigger than our bond dock.
I would lock so many people in jail in court 5, Judge. Never mind.
That, you know what? If you do that again, I'm going to hold you in contempt.
I just asked.
You are extremely passive aggressive and turn into a pouty child. You don't get what you want. You are. It's unacceptable. Unacceptable.
You told me yesterday I could carry her day
No.
for day, and I told her.
And now I'm telling you that, I'm not going to argue with you, but I'm telling you, unless something meaningful going to happen, I'm not going to do it day for day for
I
anymore.
need to approach you, talk to you about the plan that you have. I need the state to do writ calls on these cases that are holding everything.
Do you
up.
have anything else to add to it?
We can set up for trial.
Set up for trial. Good. Set up for trial. Whatever day you
Set up
want.
for trial tomorrow.
No, I have to give them time and I have to be fair to the state, Justin. Is setting it tomorrow fair for the state?
No, I mean, can we come back tomorrow to set them for trial? Or are you saying? set them for
No,
trial?
no, because it's not fair to the state. It's because we have a mental health prosecutor that's working the cases. She's not
She
here.
says she's not. She says that these prosecutors are handling the
Okay,
cases.
I don't know. I've not heard that from her. All I know is that she's been the one that's been working these cases for the last couple settings, and I don't know.
Only me.
Do you have anything meaningful that's going to happen tomorrow?
We can set it for trial tomorrow. Maybe not try the case tomorrow. Tomorrow we come back, bring more supers, bring whoever you need here, and we set.
Can you reach out to Ms. Stubbers, please, to see if she can come here now, please? Thanks. All right, give me a second. Let me see if we can get her here. Hey,
Okay, can you pre-tell this? We got some development on the case, okay? Thank you, Councilwoman. This is the one that I approached on about the income monitor. It is working. And that's what my client had told me. And so she just confirmed she did get a new.
No, but she didn't let them download the information to find out things. She refused to let them download it, correct?
Yeah, so I took a look at the timeline. So on Monday, she came in and she got a new device and then it still was not working because she said that it was a charger issue. But we couldn't give her a new charger without the old one, and so then that's when she showed up yesterday. And she brought us the charger and we said, can we look at the device, because we still don't know if it's a charger issue or device issue, and that's the issue.
But she got a new charger and she charged it and it's working now. That's my thing.
Are there still other bond violations?
So she had a cell, no GPS battery from about 2 o'clock.
She needs to be here so I can admonish her. There's already one bond violation. Presumably, it might happen again, and I'm going to admonish her that there's absolutely no tolerance going forward. So she still's got to be here.
Okay, good.
Sorry.
And then, sorry, I'm here on bond condition, even for the other case I talked about, the DWI, the police.
Sure.
So, two questions. One, he sent me, basically the invoice and everything, and it's an alcohol-free pass, Judge. So he's not gonna even be able to have alcohol on the.
I don't know that for sure.
Okay.
I don't know that.
Can you test me vaguely?
No, because I won't be able to see if he has it. I don't, after 24 hours,
It may go.
alcohol dissipates from your system. And I do not have a test that will reflect from, if he could conceivably drink on Monday, comes back next Monday, and I will never know.
And then, can we waive his signature so we can?
Yes.
Take the pretrial? to do it?
Yes,
Agency paid?
I'm okay with it.
Thank you, Judge.
Yep. Hey,
Judge, Galen Valley. She appeared this morning on a VDR. I thought I saw her sitting in the box.
give me 1 second.
Yes, sir.
I'm gonna need you to go on the record with him. When Ms. Stubbers comes, I'm gonna go on the record with Justin,
Oh, okay.
please. Okay,
Galen Valley, she was appearing today on a VDR. She was present in the box earlier, Judge, and she's disappeared. I think the bailiff's asked her to step outside and maybe she misunderstood. She left or
okay.
whatever.
You wanna roll it till tomorrow then, or I guess till beginning of next week?
Yeah, let's roll it again.
What's the bond violation?
The bond violation was that she failed to show up for a UA.
Okay.
But Judge, when we put her on, when you put those conditions on, she was homeless and didn't have a phone.
Right.
And so,
All we have to do is go take a drug test.
right,
So I'll set up for bond forfeiture. All I wanted to do is go take a drug test,
gotcha.
you know?
I wish I would have been here earlier.
I get it,
I'll roll her in next week.
beginning of next week,
Beginning
okay?
next week,
Yeah.
okay.
SFDF.
Thank you.
Yes, sir. Ms. Washington, you ready?
So we're waiting on the interpreter.
Okay, all right.
Yeah, I'm just waiting.
Hey, you have an arraignment? Oh, he's here.
Oh.
Spanish, right?
Yes.
Okay. Do you need to talk? Mr. Perkins, do you want to talk?
I have a plea, but I'm missing one signature, so I've got it.
Okay.
It's a Walter.
I need, hey, Luis, can we borrow you for a second? Luis, can we borrow you for a second? Do you have a cause number?
I do, Jeff.
What is it?
262. Yes. 76401. Assault family.
What's the last name? Or, oh, don't worry, I'll get it.
Yes. Also.
Did you get the cause number? 2627641.
Yeah, we have a bonds person here as well. The court agrees.
I have Mr. Metz signed on to the case.
That's correct. His office is here. So I'm standing at first.
Ah, okay. All right, you are Miss Alberto Hernandez. Ma'am, you were charged with assault of a family member. You were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On June 28th, 2026, in Harris County, Texas, officers responded to a call in reference to a family assault. Officer met with complainant who advised he was assaulted by his wife. The complainant or the defendant arrived at the location to pick up the belongings. Complainant reported while inside the residence, the defendant began arguing with him. Complainant advised he no longer wanted to be inside the residence and attempted to exit. Complainant advised the defendant placed her body in front of the door and refused to allow him to leave. Complainant reported as he continued trying to leave the residence, the defendant struck him one time with an open hand across the face. Complainant was able to leave and call 911. The complainant reported feeling pain during the assault. An officer observed redness and swelling on the right side of complainant's face.
Okay. Ms. Hernandez, I'm going to find that there is probable cause to go forward with your case. As a condition of your bond, you were ordered not to have any contact with the complaining witness in this case and not to be in possession of any weapons. I am entering now what's called a magistrate's order for emergency protection, which is a court order that identifies Mr. Sanchez Maximo as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. If you violate this court order, they may file additional cases against you. In a violation of protective order, they can file it. It's one of the worst misdemeanor cases you can pick up. I don't know what your immigration status is, ma'am. But if you are not in this country with proper permission and you go to jail and immigration finds you, they may place a detainer on you and you may be in custody for a very long time. You have a lawyer. It is your responsibility to stay in touch with counsel. If they tell me they cannot get a hold of you, if you do not show up to court, then likewise, a warrant for your arrest will be issued. Let's talk about a bond.
Judge,
You have a request?
much about this summary, I'm stepping in from Mr. Metz,
Sure.
but I'm told that she could make a bond of somewhere between $1,500 and $2,000.
We'll defer to the court, Your Honor.
I was going to grant you a PR bond if you want one. Does she have any criminal history?
I'm running for NCIC right now, Your Honor. No criminal history, Your Honor.
Okay, I will set your bond at $100, Ms. Hernandez, and I will grant you a PR bond. I want you to understand this is not a revolving door. So it's not PR bond after PR bond. If you are a danger to our community, things will not go well. Do you understand?
Yes.
Okay, we will have all the paperwork drawn up. They will have bond conditions created for you to sign. Once you sign that, and then the PR bond after that, you'll be free to go.
Thank you, Judge.
Oh, good call.
Judge, the conditions are no contact order.
Please. Yeah, thank you so much. Yeah, let's do it. All right, Mr. Perkins, you ready?
Deja Turner,
Yes, ma'am. Yes, sir. All right, good morning, Ms. Turner.
Have, one question, can we, can you bring the court costs concurrent?
Is it a true first?
Yes.
Yeah, then yes.
And, I told her you'll set the suspension and there was something else that escapes me at the moment. Oh, the surcharge, you need that form filled out?
Correct.
Okay.
Yes, Ms. Turner, you're charged with driving while intoxicated. First offense, it's elevated to a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement. They're offering you 12 days in jail with credit for the. Is that right? So she has time to do.
Yeah, she still has, she's got to go in and do 3 days.
Okay.
That's why I was asking, can she, her court costs run concurrent with?
Is she going in now?
Yeah,
Do you-
yes, sir.
okay, all right.
Excuse me, I apologize. Yes, sir.
Okay, so understand it's 12 days in jail, credit for the 1 day that you've done. You need to understand something very important, that this charge will go on your record. It will be there forever. From now on, should you pick any further ones, you'll be facing a minimum of 90 days in jail. You understand? Every time you get pulled over, officers will see this DWI. If they come up to you and they smell alcohol, they smell anything funky, then it just may not go well. So for the rest of your life, if you use, I just be very, very careful. You understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Do you understand? If you're on probation or parole, this can be used to revoke that, resulting in further confinement. How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty. I'm going to suspend your license for the minimum, which is 90 days. Do not drive until you get a license. I will roll your court cost for you today. I'm rolling about $6,500 worth of fines and fees for you today. Ms. Turner, you don't get to redo over and over and over. If you pick up under the DWI, a second, it's a surcharge of $6,000 at a minimum. And if you don't pay it, every $100 you owe, it's 1 day in jail. You understand? Be very careful. I would, if I were you, for $30 an Uber. Good luck.
One last, there's, go ahead. Just, I've had some fun with the DVRs in court in her particular case, because she had too early on DVRs, that's why they denied her. But during the next 90 days, gave her the scram, and on the low device, she had one come up, but on the scram device, she was perfect. So I don't know if the low device was off or the scram device, but I'm giving you some information.
That's why we tell
give
them, you know, when you blow, it could be a false positive. Wait at least 20 to 30 minutes before you do, so that there is no false positive, because who knows what it is.
In my checking those records though, I just wanted to let you know, sometimes one or the other could be.
Okay.
Thank you.
Tyler left.
Yeah.
Well, you represent Stupers, STUPERS.
One of them is 2627300. Do you need it all of them?
You guys ready? Come on up. Before we get into the case, I need to address something with you. We are on the record in cause number 2601312. For purposes of the record, I would like to state that I was having a discussion with the defense lawyer, Justin Harris, and Mr. Harris was rude and passive aggressive. This is not the first time that this has happened. It has repeatedly happened in so much that in December, if I remember correctly, he called me a Grinch. I had a bunch of students out here speaking and trying to make a point in front of the students. And he tried to dress me down in front of the students, which was extremely disrespectful, so much so that the students and the professor really took note. Today, again, July 8th, 2026, passive aggressive and rude happened again the other day, where today he made the comment that why is everybody in court 5 always in jail? And I really take note to that. And I'm going to tell you that from now on, the interactions that you and I will have will be always done on the record. So from now on, when you and I discuss whatever case it may be, it must be done on the record. We will have no more discussions unless there's an actual court reporter here taking every single thing down. Okay?
May I respond to it?
Sure.
Okay, I like that because the law is actually that everything is supposed to be on the record that can happen in the courtroom unless both parties agree to waive it. So the court should be taking every single thing on the record. And I'm glad that we're gonna be doing that. I will say for the record, I did not I did not say, why is everyone in court 5 and it's full over? What I did, the court indicated that yesterday on this case and my client's cases, the court indicated I could carry her day to day until I have the information that the court requested I get to consider her release. And so today I asked the court to carry the case to tomorrow, like they did yesterday to today. And the court indicated to me that the reason that could not be done was because the court's holdover was full. So I just asked, why is the court, you said that you have more people on the jail docket than you do the bond docket in your misdemeanor court. So I asked the court, why is the court 5 holdover so full? I didn't imply that there's too many people in jail. I didn't use a judgment call like the court seems to think that I did. I don't think that I was rude in any way. I don't think that was passive aggressive. I think as both a taxpayer and a practitioner in this court and someone who's being told the relief I'm seeking is denied for that specific reason, I think it's a valid question. You cited the holdovers overcrowding as the reason why my client can't be put on the docket tomorrow. And I don't necessarily even need her here if the court doesn't require her appearance, but I need to be able to address the case on the court's docket. So if it's because of the holdover is too full, I don't know why my question about why the holdover is so full. And it seemed like there was enough space for there yesterday and today. I don't know why that's an invalid question, and I don't know why the court takes offense to that. I think the court should be receptive to, accountability and answering questions of people who practice in there, and as well as the voters of Harris County and the residents of Harris County. That's all I was exercising my First Amendment right as. So I'm not sure what's offensive about that to the court. And the court recalling previous incidents, I don't know what that has to do with this case that's on the docket today. And all I'm asking is what the court told us 2 days ago and reiterated yesterday by allowing is if we just carry her case to tomorrow, we have someone who's the state feels is not mentally all there, has mental health concerns. The state's indicated they have an orange sheet with mental health history that's unspecified. I have concerns about my client's mental capacity for her developmental capacity. And she doesn't speak the primary languages that are spoken over at the jail. She speaks a dialect of Ethiopian. She's a very vulnerable person in the jail. She's being held on a $200 bond on a Class B criminal trespass, where the warning, according to the dim summary from the state, the warning for the trespass comes the same day as the arrest. And she's not in a business, she's outside in a grassy public space that I don't know if anybody could discern if this is private property and this is not private property. But again, the court is holding her at great expense to taxpayers. The court is paying me for my representation of her. And I'm just trying to get the court the information that you've asked for yesterday regarding the plan for her release. I have told the court earlier, I have plans this evening to speak with her father, we've got contact information for him, and her brother, who I'm trying to get contact information for. Her sister, who I told the court about yesterday, is not in town right now. So I don't want to bring that information to the court, like let her go back to sister's house when sister's not there. I'm trying to bring relevant material information to the court that the court requested. And the court is now throwing up a hindrance to that by saying you won't do what you told us you would do 2 days ago, which is carry the case day to day.
Give a response.
far as the allegations we discussed earlier between the court and defense, the state was not present
You wanna
for
be in
that.
that?
Personally, I just, fun fact, council, did you know that court 5 is fugitive document?
I do.
So that might, I don't know if that's the reason, but just throwing that out there. As far as the allegations, I will defer to the court's ruling yesterday that he was not going to reduce the bond. I'm opposed to a reduction of the bond in this case for reasons I stated yesterday, but.
The reason I wanted to bring you in here now is because I did not want to continue rolling this case day for day. We have way too many people that are on the docket getting rolled day for day. It's not fair to the other inmates who are crowded in there. It's not fair to court 8 because we're having to put people in court 8. So I don't want to continue to do that.
Yes.
Mr. Harris's response to that, well, let's just set the case for trial. And I said,
Well,
I'm not going to stop.
that's what I said.
Stop. I'm not asking you to respond at this point.
Okay.
I'm talking to her.
Okay.
So before we set the case for trial, to be fair to you, because you're the person that's been here in the last couple settings, I'd like to know what your response is before we set this case for trial.
Certainly. My response is that I was opposed yesterday to rolling day for day due to the fact that I don't see us moving forward until we get the results of that competency report that defense filed for. Now, I have extreme concerns about defense now wanting to set this case for trial because he previously asserted to myself and the court by filing that he believes his client is incompetent to stand trial. So it's my understanding now that you want to still set it for trial, even though we believe she's incompetent.
I have never said that I believe she's not competent to stand trial.
We got a comp evaluation
Right.
per a filing, no? Am I
Yeah, no, that's
correct on
correct.
that?
It's a psychiatric
Or you
evaluation request. The
assert
state asked us to
That she
do,
may be
One at a
incompetent.
time.
the state asked us to file that because the state indicated to me that a lot of times those evaluations will come back and indicate if there's any kind of intellectual disability that they're starting to note. So that's why the state wanted us to get that evaluation done. I don't right now have enough information to say that she doesn't understand the charges against her, that she's not able to aid in her own defense, and that she doesn't understand the role of the parties in the case. That's the legal definition of competency. So, but at this time, I don't have any of those concerns on those 3 things as of today's date that we're on the record. Additionally, the court asked me what we could do tomorrow that would be something meaningful on the case. And I said that if we came back tomorrow, and now Ms. Stubers is here, but if I'm able to get the information that I have, I can present that to the court about her release. The court makes a decision on that. Then we may set the case for trial. There was some confusion at the time. I'm not asking to set the case for trial.
Legally, we may not.
I'm just trying to relay what we talked about earlier. You weren't here at that time. And so, but the state who was at the bench with us at the time indicated that, well, the court was under the impression that the trial prosecutors in this courtroom are not handling the case. And I relate to you that Ms. Stubers told me that she's not handling the case. She just oversees the mental health pretrial intervention if it ends up in that way. And it's not being offered at this time and it's not at that point. So, and then also Ms. Shaw, Shantia Shaw, who's the prosecutor who's handling the case for the state, indicated to me in the hallway before we came back in here that she has no problem setting this case for trial. And so the reason why I was saying we come back tomorrow, and the court asked what we could do tomorrow. And I told you I would have the information the court requested yesterday about her release plan. I think that's meaningful that we could do tomorrow. I also think that if that doesn't work, if we have that information and the court's not satisfied with that, then at that point, I'll probably need to set the case for trial. So that's what I was responding to the court for, is tomorrow what we could do is we could set the cases for trial, as well as present you the information I'm trying to get this evening.
I will note that council did send me an email yesterday evening saying that he would set it for a trial and request a speedy trial. Also, I would like to note for the record that I do not subscribe to any of the statements that he claims that I have made. I know for a fact that they were not said in the way that council maybe understands them to have been. Because it is not true that anybody from the Harris Center during a competency to stand trial evaluation evaluates a client, a defendant, or anybody for intellectual disabilities. What I told council, I remember specifically, is that sometimes they will indicate that that might be present. However, they cannot make that diagnosis in the exam that we undergo per the filing by counsel that states he filed this motion. I don't request counsel file these motions. I am able to file them myself, Your Honor, if I wanted to, I would. But counsel did file this one himself on May 8th, and he says, quote, defendant has a history of mental illness. Defendant does not have sufficient present ability to consult with the person's lawyer with reasonable degree of rational understanding, and or defendant does not have a rational as well as factual understanding of the proceedings against the person.
Are you telling me that he emailed that to you?
No, he filed that. This is the filing that counsel made to get the competency exam done at all, which we did then expedite personally, and it came back in a week versus the usual month long that it takes.
So
to get someone
it's back
examined.
though.
They did the evaluation.
It's not
the other
back yet.
day, and it's not back yet.
Okay.
And that is exactly what I've
Okay,
been
I'm not
trying
gonna
tell
set this case for
counsel.
trial if you're alleging that she's not competent.
That's like I told you a second ago, it's on the
So you've
record.
withdrawn your allegation that you believe that
Hold on a
she's
second.
incompetent.
Hold on a second, like I said a second ago, as of July 8th, today is today's July 8th, I don't have the concerns that she is not able to aid in her own defense, that she doesn't understand the nature of the charges against her, and she doesn't understand the role of parties in the case. At the time of the filing, I didn't have the information that I have now. So no.
What has changed between, when was that filed?
That was filed on May 8th, Your Honor, and then we were discussing more about getting the comp report done per my case notes on, I believe, June 30th. If I'm not mistaken. That might be in my emails.
So you're saying you have no concerns about any competency whatsoever at this
time, I don't
point?
have anything that I could say, this makes me concerned about this issue, or this makes me concerned about this issue, or this.
So you're saying she's competent at this point?
I don't have a way to say that she is or she isn't something. I'm just saying I don't have the things that are required for me to go, I have concerns about competency at this time. But I'm telling the court on the record with my bar card on the line, that the reason why the state indicated we should speed this along was because, like she said, that might indicate IDD, if IDD is going on. And I don't know what the record says, but my recollection is, I'm not saying that the state said that 100% they're going to
Okay,
diagnose her with
I'm not
IDD.
trying to get into,
But
I
they
just,
said-
how do
they
we go
told us.
forward?
I'm just telling you what the conversations I was part of and what made me motivated to agree to the things that we agreed to was the state indicated that, as they said today, now, that sometimes in these mental health evaluations, the evaluator will note if there's intellectual disabilities. In fact, I feel like we even emailed Helena White earlier this week and we asked her
Yeah,
to
you
look
said
for
to
that.
do that,
So-
however, she never responded because they can't do that.
But just try not to be interrupted, Judge. But the state was party to all that. The state indicated to us that the IDD, that's what we're looking for. Because the
What
state
do you
is-
want?
I want to carry her to tomorrow so I can bring the information to the court about what she's got going on, what her release plan will be.
But you say there's still someone else that you may need to talk to because you may not have everything tomorrow.
I have her dad's contact information. I need to get her, he and her sister has her brothers. When I get out of here and I can make phone calls, then I can call and get her brother's information. Between her brother and her dad, I think we can get together, we can put together the plan that the court needs to consider her release.
By tomorrow?
Yes, sir. It's just gonna be a matter of conversation. They telling me who her providers are.
I asked you for proof other than word though.
I know. Let me see what I can get to you. But that's the thing is if I'm able to get it and we have somebody that's got these kind of capacity issues in the jail who doesn't, English is not her primary language. She's vulnerable in the jail, Judge. And if we have that tomorrow, I'm just asking to carry.
And what if we don't have it tomorrow? You're gonna want to carry it the next day too?
I thought that's what you told me 2 days
Okay,
ago. We could.
yes, I'm now changing my mind
Okay.
because we have way too many people in the holdover now. That's why.
You just told me today that you're changing, just now
Yes.
you're changing your mind.
Sure.
So, and I've just been asking for what the court previously told us before you told us.
I
you
will
changed
give
your
you
mind.
tomorrow, but if tomorrow there is nothing that is changed or a different plan, I'm not going to continue to roll it day for day for day
Okay.
for day.
Okay.
Okay?
I
But I will
understand
give you to tomorrow, but after that, if nothing has, I'm not going to continue to do this day for day.
Understood, because I get that, because I'm sensitive to the fact that Fridays, especially after a holiday weekend, are gonna be slammed crazy for
Right.
probably in your holdover. So we carry to Thursday, and if we don't have a resolution, instead of Friday, we do like Monday or Tuesday.
I'm not going to commit to anything at this point,
Okay.
but I'm telling you that I'm not going to do day for day anymore.
Okay.
I will do today to tomorrow, but after that, it's just if,
That works.
Just for everyone to have full information, I am out of town on Friday and Monday.
okay, great. So we will wait, obviously, for you, but let's see what happens tomorrow.
Okay.
Okay,
Just for the record, since my name was brought up, Shantia Shaw for the state, I did not outside tell council that I am ready to set this case for trial. Council was threatening that what if I set this case for trial? If you don't do the RIP, I said, you have every authority and every right to do as you wish with your case. And I told council that my understanding is that the RIP has nothing to do with holding this case as of right now or for his client to be still in custody right now. And that was the conversation. So I just wanted to clarify that I did not say we're ready to proceed with the trial.
all right.
I'm not saying that she said that she was ready to proceed. She did say that she was fine.
It is what it is.
Okay.
Just, all right.
We charge it tomorrow?
Yes,
Thank you. Off the record?
off the record.
Thank you.
Do you have a question? Hold on. Let me.
Yes, sir.
Hello.
Hey, are you here?
Yes.
Can you come back up real quick?
Yes.
Thanks. There's a question.
Okay.
Bye. All right, he'll be right up.
Yes.
As soon as we, ready?
Mine is easier. Judge, did you, email Ulysses for the laptop?
Oh, no,
That's what they're asking for, right?
right. Thank you for reminding me.
Only we get found, but if you wanted us to notarize and repeat what you can't do, you want to only and put it in. The district court site, it's all would be there.
Oh, we need a laptop so that jurors can view a video, please. Thank you so much.
Put it on your, just.
Tyler. They just want to look at the body cams for both officers, so I just wanted you to see it. They want to see both body cams, Reyes and the only thing is do we have the right ones there so we know which ones they're getting? I guess you want to make sure.
We gave it yesterday, we edited them all, the way that was supposed to be and submitted them to them.
Like the HGM, the video part with the executive.
Yes.
You want to take a look real quick?
Yeah, just do that.
I mean, we're waiting for a computer for them anyway, so do you mind just looking real quick just to make sure, please? Okay.
Wait, let me see something.
Talk to me.
I'm gonna wait until they,
It's okay. They're gonna look at video.
case on docket today, Judge, 2628004, last name Garcia.
Garcia. Okay,
So he got booked out on 7/1. It's a refusal, but he's enrolled day to day because he's being combative with the jail, so he's not being brought up because he's being so combative. I don't know if it's physical or verbal, but it does prove to show that he's also charged with harassment of public servant and retaliation, so he threatened to.
yeah, you see the spit guard?
I'm sorry?
See the spit guard?
So
Yeah.
part of it is because the next setting for the felonies in the 42nd is the 29th, I didn't know if you wanted to appoint somebody to go to the jail or if you wanted to just keep rolling until.
No, he needs a lawyer. We can't just continue to. Victoria? Let's appoint a lawyer. We'll see if they can get out there. If not, then we'll do maybe a Zoom from the jail.
After
But
the third one, I usually ask and Mama checks in, make sure it's not medical or something else. So he's just extremely combative.
you ready?
I'm ready. I'm ready.
Okay. On Garcia jail case, Victoria,
Yes, Judge.
He's been rolled day for day. He's not made it up because he's been combative. Do you mind just appointing him? Then we'll see if they'll go to the jail to talk to him. And if he refuses at that point, I'll reach out to admin, see how we can facilitate. Has he waived or do you refuse?
Which is part
Well,
of the
it's,
Well, I mean, but the problem is with the refusal, part of it is if it gets to the hearing, he is afforded an opportunity for an attorney. So ironically, by making it more
So
difficult.
then let me clarify.
Oh,
So
sorry.
he technically didn't refuse. PC Court could not get him to come because he was spitting at the detention officer. So Judge Chu just did the refusal. Because if that's the case, they were gonna keep rolling him on probable cause.
The problem is unless they affirmatively waive away their rights by legal defaults to refusal.
Okay.
So
regardless, we'll get him a lawyer, have the lawyer go reach out to him. If it's at that point, they're still refusing, then I'll reach out to admin and then we'll get Sylvia involved.
Okay.
Yeah, okay.
I'll check in tomorrow and then.
Yeah,
figure it out.
okay.
Thank you.
Thank you.
Thank you, Judge.
Are you ready, Alan?
Lauren?
All right.
I got it. That's what I'll. Oh.
All right.
It's not this one, right?
No.
All right. Good morning, Mr. Godfrey. So,
I didn't know they had children.
he's only planning on one.
Yes,
The rest are being dismissed.
yes, Your Honor.
Okay.
Your Honor, if I may, I had asked if we could get the assignment to fill the court. This is just a statement that I had Mr. Godfrey sign acknowledging that he understands that there was a global offer that is being made that, against the advice of counsel, he's pleading guilty right now. Understanding that if there's a PSI that will be upstairs, that they could take into consideration the convictions associated with this court. I have advised him of all of these things, and he still decided he's running to plead guilty. So I did just want to have that on my record. Again, I don't know if I can get the statement signed by the clerk, I mean, stamped by the clerk of the court, for to do so.
Did you hear what he said? So it looks like it's a kind of a CYA type thing where he files it under seal. What do you think?
We told him we can file it, but if he files it under seal, we just need a prescription saying that you grant to file it under seal. Because he wanted us to just kind of notify him. And I guess he keep it, we can't do that. It's not a district court document. But if he wants to file it in his case, we can do that.
Yeah. When it's under seal, will he get access to it?
No.
You hear that, right? So when it's under seal, they're not gonna get access to it. I don't think that you get access to it either, though.
In that case, Your Honor, I would have preferred if I could not have it stamped, at least.
I can make a docket notation. If you want, we can put it on the record because I've got Ramona here as well, already ready to go.
Yes, that's the next question.
You want to do that?
Please.
Ramona, I'm so sorry.
Wait a minute.
Your Honor, Mr. Godfrey.
She's earning it today.
This is Mr. Godfrey's last time being in trouble, but he is the case that keeps on getting.
You know, I hope no one wants to see you just become another statistic, but you know, a lot of this life is who you're with. Are you with the wrong crowd? Are you the wrong crowd? But Mr. Godfrey, here you are with 1, 2, 3, 4, 5, 6. And a lot of them are dangerous cases. So, you know, at some point, your decisions become your own. At some point, all you're doing is running to prison and life as a young Black man in today's society. It can't be more difficult for anyone than you, my friend. And by picking up all these cases, instead of getting your butt into school and trying to learn something, so you're charged with, oh, I'm sorry. Are you ready?
Yes.
All right, we're on the record and cause number 254-6510, 254-6509, 258-6956, 258-6955, and finally 261-3612. 1, 2, 3, 4, 5. The agreement that you have worked out is 180 days in jail, 6 months in jail for credit for the 96 days that you have done. understand something important is that it's very possible that your lawyer may work out a global resolution with regard to the case upstairs and with this case downstairs, so that there may be a whole different resolution. Not only that, depending on what you do upstairs, by pleading guilty, they may also use that against you upstairs. I don't know what's going to happen, but when you get convictions on your record, it's very possible that they're just used against you, resulting in further confinement. You understand?
Yes, sir.
I'll give the floor to you so that you can
Thank you, Your Honor.
tell me whatever you would like, or the court, or.
Yes, Your Honor. On today, July 8th, 2026, I did speak with Mr. Godfrey, where he did in fact sign a statement that says in part, "My name is Javion Godfrey. I acknowledge that my attorney, Alan Woodward, has advised me of my rights," which signed. "I have the following misdemeanor charges pending: 254-609, 254-6510, 258-6955, 258-6956.
Hey, hey.
Oh,
Really?
sorry. I'm sorry, I forgot.
Slow.
I forgot you. When you started with the numbers? Okay. 254-6509. 254-6510. 258-6955. 258-6956. 261-3612. I also have a felony pending that could result in a sentence of more than 10 years in the Texas Department of Corrections if I am found guilty of the summoned. I have been advised by Attorney Woodward that it may not be in my best interest to plead guilty to any or all of the misdemeanor charges. I have been advised that the state has considered and offered to dismiss all misdemeanor charges with a plea of guilty on the felony charge will be signed. Against the advice of counsel, I am rejecting any offer from the state to globally resolve all cases which he signed. And I insist on pleading guilty to any and or all of the misdemeanors listed above. Signed, J. John Godfrey.
For purposes of the plea, he's pleading guilty to one
Yes, Your
and four being dismissed.
Yes, Your Honor. For the purposes of the plea, splitting to 261-3612. Self-nomination.
Knowing that your counsel is advising you against this, do you still want to do this?
Yes, sir.
Okay. You're charged with assault, bodily injury. You're facing a year in jail and or a $4,000 fine. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, this will go on your record. It will be there forever. You can never change it. You will now be facing, for any Class A misdemeanors, a possible up to 90 days in jail for any future offenses that you may pick up. If you're on probation or parole, this can also result in further confinement. Knowing all this, do you still want to go forward?
Yes, sir.
How do you plead guilty to the assault? Guilty or not guilty?
Yes.
I'm going to find you guilty. I will follow the agreement. As far as the weapon is concerned, it will be forfeited to the state. And good luck to you, sir. Okay, we are done. And as for purposes of the record, the other four will be dismissed on motion of the state.
Israel.
Okay,
Thank you, Your
all
Honor.
right, off the record. Okay,
Mayor Thomas, I'm Tom Sawyer, Your Honor, Your Honor.
yes, you've satisfied. It is,
It's 96 days for this. And it's-
6 months. So it's, hold on. Let me just make sure, because I don't want to tell you wrong. Yeah. Assuming they give you, the credit that, you've got sufficient credit. But You need to be careful, man. Every day, people are dying out there because they just make the wrong decision, just in a moment's notice. Do you understand, Mr. Godfrey? All right, good luck to you, man.
Thank you, Honor.
Yeah, let me talk to Mr. Washington and then, hey,
I'm circling back on this, Hernandez.
okay.
Walkthrough, we just need to get you.
Oh, yeah, I'm so sorry. I'll get it done. Do you want to bring her up?
We've done everything, except the bond conditions.
Okay, I'm signing it right now.
Thank you so much.
Of course.
You guys are correct.
Okay, are you ready on that arraignment? Let's do it. Coming up, sir.
Judge Jones, Harrison is coming up.
Harrison, what time did Mr. Harrison get here? Is that right?
I didn't have them marked off.
We don't have you marked off. If you don't come in and check in, no one knows that you're here and you end up waiting. This is what, I don't know. Mr. Harrison, you're charged with harassment. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Harrison. He has an assault that was dismissed, 1, 2, 3 that were dismissed, not 3 months ago, man. Go ahead.
May 8th, 2026, officer was dispatched to a location in Harrison County, Texas. Complainant observed a vehicle that belonged to the defendant that she knows have been briefly trespassed in that location. Complainant allowed the vehicle on the premises because the driver was a female and she did not know he was inside. Complainant noticed the defendant walking around the property and took pictures of him to document his presence for the company records. Complainant stated the defendant saw her taking a picture and approached her aggressively, yelling at her, and put his hands inches from her face and said, quote, "Bitch, I will slap the fuck out of you," quote, "I will beat your ass," and quote, "I don't care if you're a woman, I will beat the shit out of you." Defendant threatened to wait for the complainant to get off work and stated, quote, "I'll come back and beat your ass in your parking lot." Pictures and videos confirmed the defendant to be on the premises.
What is this place, please?
It's I believe it's a company, looking it up right now, I think it's Watco Company,
What is it?
Watco, WATCO. Yeah, a company called Watco.
Mr. Harrison, I'm going to find that there's probable cause to go forward with your case. I want you to understand something. I want you to hear me loud and I want you to hear me clear. I'm going to do everything in my power to protect my community. And if I have to throw your butt in there and give you a $5 million bond, I will do it in a freaking heartbeat. Everything. You so much as any violation, it's not going to go well between us. You are ordered not to consume alcohol or illegal drugs, and you will be tested. It's not a matter of if, it's when. And I'm telling you, within 50 days, you will be tested. You test positive for anything illegal, it's not going to go well. Do you understand me? This includes marijuana. This includes unprescribed controlled medication. It includes alcohol. You are not to be in possession of any weapons, and I will give you a GPS monitor, and you're not to go within 1,000 feet of this place or the complaining witness. Do you understand? Do you mind tagging on the device on the GPS monitor so that the complaining witness knows if he goes near, please? Test in 50 days. We are going to reset your case to give you time to hire a lawyer. So I will have you sign a reset. You will get with pretrial bond for your bond conditions. Any violations? Do you understand me?
I will sign.
Yeah. Oh, you need me on sign?
Yes, it does, it's already for activities, it says.
Got it. Yeah. Hey, Ramona,
Yes, Judge.
can I talk to him back for a second?
No, I knew it was gonna, ready to set it for speech trial yesterday. I was like. I still look good, but it didn't need to. That's good. Yeah, I don't know nothing.
Well, we need to in our marbles for. It's in this water.
I should have had her. Do you want me to leave it as a jury trial?
Hey, is that Morales over there?
He was worried about the length of the chair for months. I can look at it.
Hey. Do I need to answer? I don't need to answer this, right? Can I just sign it and?
Just give it to the clerk so they can put it in the file. You don't have to answer.
Sign it.
Just.
Yes, ma'am.
Thank you.
My thought that he for the most part.
That's okay. Morales' lawyer, she was here earlier, I know, but
She said she is a
no, but he has today court.
only because he's on the show on yesterday, but he didn't make it up, so for today, his bond people, the attorney showed me said that because it's not conditions. So she said she put it down.
Yeah, I don't want to wait that long. It's his third case, man. You know, really, it's time to. So, two sixteen. Hey, can I talk to you for a second? I want to reach out to, she left, the lawyer from Morales left, but I'd like to reach out to her to get her here sooner. He's on his third case now, so I'm not gonna just sit here and wait and, because half a week. It's time to, so I just want to let you know, so that way I'm gonna see if she can come in tomorrow or maybe Friday.
I may, probably won't be here.
Yeah, okay, I guess I should have said Ms. Shaw.
I'll let him.
I'm reaching out to the lawyer for him to try to get her here. She left already, but maybe tomorrow, the next day, Morales.
Oh, you did? Okay. I just want to make sure neither of us. You know, you know, yeah.
Hi, Steph, it's David Fleischer. Hey, are you here tomorrow or Friday? Right, do you mind, can we do it tomorrow? Yeah, he's picked up a new case and we need to do bond condition. Yeah, sorry, we were in trial today and it was just really hectic, but. Yeah. That's okay. Are you okay tomorrow? Okay. Got it. But I don't know, I need to know what else, if anything. And, you know, so we'll put him on for tomorrow. Hey, I'm gonna be a little bit late tomorrow because I have to do something. But if you want to maybe pop in like 10:30. Okay? Okay. All right, thanks. All right, take care.
The R word on the record. Today. Yesterday, he kept calling her mentally. Yeah, he said.
Really? I guess,
Yeah, he didn't say it.
thought I heard, but.
No, he did say it yesterday. I looked.
R.
Just for the record.
Oh, I'm talking about Morales R. Hey, Morales R. I guess she sent him on the way.
I know, I said last name.
Is he out there?
I don't know if he's out there now.
Okay, hey, can we roll until tomorrow? I spoke to Steph, she's okay.
Yeah. She said, okay.
Yeah. I don't know.
She said she don't know that. But she said that they should.
There's an arm that says,
They just think it's more. I just think to them, they should be back to teacher. Did you see?
Oh, I don't even see Morales J.
He's on page 44, Judge.
Okay. Yes, this is the guy that I'm talking about. That's not, there's no J. That's Rafa, that's right? This is Stephanie's client.
It's two different spin numbers. Yeah, that person over there is not Rafael Morales.
Yeah, it doesn't look like him. That's not the one I'm talking about. That's, do you have a lawyer?
I don't know who that is.
Do you have a case on the docket today?
His lawyer is.
What's the spin that you got?
Christian from Appleton. What's his name?
Or do you have a cause number maybe?
Yes.
What is it?
It's 26138555.
I know I saw Christian here earlier.
Yeah, he was there earlier. Yeah, that's the case with me, Judge. I don't know why.
Yeah. Do you want to maybe just give Mr. Morales a copy and we'll send him on his way?
Come on, that's Mr. Morales.
Come on, we'll send you, your lawyer was here early and reset the case, but did you not talk to him? Okay, we'll give you the new reset date and we'll send you on your way. Okay? Sorry, you'll have to reach out to him. I can't talk to you without your lawyer. but we'll just give you the new date if you want to reach out to him. They have a verdict.
You have their. Oh, you say, yeah.
It's part of the delay.
What'd you say?
They
have a verdict. Yeah, hey, they have a verdict.
But I'm in the restroom right now, so say give a few seconds.
Sure, I get it, verdict, yeah.
I didn't read it.
Hey, they have a verdict.
No one ever does.
Nobody ever.
Come on up. All right, bye.
Okay, it looks like
No. True. They weren't just filling their thumbs the verdict back there.
Yeah, just let him know. Yeah.
Who?
William?
No, he's telling her.
So where'd you go? Where are you, 12 now? How's it going?
It's good.
Yeah, you spent still so much time with us that, you know. You're home away from home. Yeah,
I've been here more than.
we're happy to have you. Dang, see, that's a kick in the ding ding.
I thought it was a horrible day. Just.
Right, see, no, she moved to 12. Court trial, wow. But you guys agreed to the court trial. Oh, that's cool. Yeah, I think I've only done one.
No, it's much simpler.
Thank you for the help.
Yes, sir. Everybody's here?
Are you guys ready to bring the jury in?
Yes, you're right.
Okay, let's go. Yeah, for sure. Hey, anyone you want to talk about?
That was the last one.
But no FTAs or anything?
No. Oh, sorry, Judge, page 25, sexual arraignment, both of them.
Bottom or both?
Bottom,
2501. We didn't do the top up. Is that on air?
the bond report said 714. Oh, Judge, page 29. All over is the capital on the Defendant didn't show up today.
Okay, 5001. Or, yeah, 5001 on both. He was due here, right? Okay. On both?
Yes, Judge.
Yeah, 5001.
And then page 28, Wilson was a required appearance and didn't show up.
Oh, she called in. She was on Zoom. She took off. And then Daniel came in right after. And by the time I got to him, he had left too. So give me 5 minutes and I'll call them.
But for Watson, you didn't revoke those bonds, right? Watson, the one that was taken in on the felony over. I don't think you did. The probation that you revoked? I have the motion for the Q judge, but I don't know if you want to be with jury. Okay, Your Honor, for Wilson, I'm filing the dismissal.
Oh, great.
All rise for the jury.
All right, you may be seated. ladies and gentlemen of the jury, Mr. Foreman, have you guys reached a verdict?
Yes, we have, Your Honor.
Is it unanimous?
It is.
Okay, if you'd like to hand to the bailiff. I will read it to, in cause number 256-5785, the state of Texas versus Jaime Cruz, we find the defendant not guilty. Okay, this is all your verdict, correct? Okay, you guys may be seated. And that concludes your jury service for now. If you'd like to retire to the jury room, I'll be there shortly to talk with you guys, okay? Please.
All rise for the jury.
Oh, he signed it, okay. Yeah, we're good, thanks. Okay, that concludes it. All right, let me go back to the box then.
That's just Mr. Cruz.
You guys want to wait, you can talk to them as well. Just let me say hi to Mike real quick.
Is Mr. Cruz, you want to stay around? or-
No, it's pretty good. He's good.
Can you sign the motion then?
Thank you.
I got it. Is it a,
Thank you.
No.
It's something where they call it on employment and then they're like,
Can you
oh,
just think about it,
have.
Oh.
Like an employee. I used to get them at work and we could only run them up on, I forget what the link was.
You know what, I'll take it. I'll take it. A couple. But if you want me to. Yeah. Oh, yes. I'll stick around.
I can even find this one.
It doesn't, I think she's on the, I think she's.
Yeah.
It's just a picture.
Oh, maybe she's not. No. Oh, yeah, Carrie.
Yes.
Yeah, I'll just email her.
Okay. Sorry, it came through. Okay, perfect. Anything else?
Hopefully not.
Should we, look at anything else? Okay.
Where is that? Could you just get with it?
Yeah. Or they're. Yeah. Thank you. He's good to go. I don't need to-
Oh.
Okay. I do. I do. Just subscribe. I was just clicking.
Bye, see you tomorrow, maybe. No, you baby.
The link. To this. Yeah.
I'm just trying to put myself in that position. You gotta actually see it. You can actually-
Congrats.
Didn't hurt that.
Just I said it was the other way around. I didn't even know, so I don't know if it's. 50,000. Yeah. Back to back to back. That was funny. I kept laughing. At first I was gonna hold on, I was like, oh, hell no. It was really, I could feel it brewing whenever she started talking to everybody. Yeah, and I'm like. Just like. Oh, my God. I know, people taste it. Look, no. I just, the only question. Yeah. Just. No, I'll just, the only thing I'll say was advice.
I don't want the ultimate, say over.
We still need your service. This is great.
It's all the stuff that look at their eyes, so yeah, that's what I can see.
And wins.
And then, no, when you said it, that's what I learned. I thought you know each section, like, and then I read it. You could get it out. You could have told
Oh, yeah.
No, because that was. I was looking at
You know.
Okay,
Hey, you earned your pay today, huh?
Oh, a little bit.
Man,
Yeah.
well, good job.
Thanks, Jared.
Judge?
No, I know, I gotta sign the judgment and, yeah.
Like, please don't. And what are you sending that imaging to?
What's in it now?
2505. Get that to the parties.
Yeah, 10,006, please.
You're close.
What'd you say?
I said 50,000.
Really? Dang.
It should be 100,000.
I said.
All right, let me,